Can you hear me?
Yes, we can hear you.
Okay, thank you very much. I won't be able to use the chat, so if you have something, I'm going to inconvenience you to ask you to speak up because I won't be able to use the chat while I'm doing sharing the screen. It is exactly 2:30, and we're going to get started. Alvin Wellington Barlow is my name with Technologies for Justice, which is for-profit corporation started out of Jacksonville back in between 2017 and 2018. I believe my two business partners, Buster Bragg, who is our CTO, and Chris Parker, our CFO. I believe they'll be with us today. I don't see them right now on my screen, but I think they'll be in. If you look at our website, technologiesforjustice.com, our credentials are on that website. So I would highly recommend that you look at that. We don't have, this is only 1 hour CLE, so we don't have time to do formal introductions today. But thank you all for coming in. I know it's mandatory, but I want to thank you anyway. I think you're going to enjoy it, though, even though it's mandatory. I think in the long run, you're going to really get something out of this, especially for your clients. All right. So let me see if I can share a screen here so we can get right down to business. And we'll go right here to get rid of this floating panel here. And this is, as you saw, heard being recorded. So we'll supply the recording, the video to you all for future training. New attorneys are coming in. I know how that could be. I used to be a public defender myself back in the late 80s. I want to show you something that's very important right quick. And it is this right here, the help section. I want to start right here today with the help section on ESAS, and that stands for Equity and Sentencing Analysis System. And so you have an index here. Everything you need to show you how to work this system is built right in here. Our CTO did a fabulous job of putting everything at your disposal. And I'm just going to be frank with you. It takes a little bit of time to go through this, but I highly to the third power recommend that you take the time to initially go through this because it's going to pay you great dividends on the back end once you master this. And like with anything else, it's a new technology. And so I know we're used to doing things the way that we do them, but I assure you, I've been practicing about 40 years and I've seen some phenomenal results come from a system being used like this the proper way. So you have an index of training, and this is all that's in this. This is a deck, actually. This is all that's in this deck: the training PDF, starter document, training videos. Buster, our CTO, did some training videos. They're brief. Just go through them, and he'll show you the details, nitty-gritty details of the features and functions. I'm going to do a bird's eye view today, just to kind of show you how you can use this in court while you're plea bargaining on the fly. You also have a search function video, features and functions video. And here's where we're going to spend some time before we get into showing you how to use it. Presenting ESAS data and overview. Presenting ESAS data, example one. This one is from Seminole County, an excellent case that I sent you all earlier this morning. Hope you got a chance to look at it. That's the Joseph Miller case, 18 CF 2866A. And we have a video from another case in Brevard County, excuse me, that I sent you earlier on David Lucio. And then this video is on the Miller case. I'm going to go over those things for you briefly. So I want to come right down here to presenting ESAS data. And so you have a little cheat sheet, so to speak, showing you how to set up and this is obviously this is after you found specific cases that you think will be probative to the argument that you want to make for a sentence reduction or an equitable sentence that's a lot better than what the prosecutor is offering. So here's some dynamics that I put together a long time ago for you to have access to. So let's go to presenting ESAS data one. And this is a synopsis of the Joseph Miller case the dynamics of it, what was going on with the defense attorney and the prosecutor before that sentencing hearing. And what's important is he had a primary offense being a drug offense and a total sentence points of between 44 and 60. As you know, by statute, um, he's not entitled to, but eligible for drug offender probation. That was very, very important in this particular case, especially with someone who was already getting ready to go on the drug offender probation for a possession of cocaine case, and then picks up another case while he's out on bond. And the average prosecutor is going to lick their chops over that. And that's exactly what this particular prosecutor did. He wanted to take maximum advantage of the fact that Mr. Miller, he was basically a drug addict. And what do drug addicts do? They're addicted to drugs, so they're going to go and get some drugs. And so we're going to see from the video in a few minutes what the dynamics were. Here's this is a very important document right here. If you want to present a sentencing memorandum, which I highly recommend if you do an open plea, or if you're using ESAS as part and parcel of a contested sentencing hearing after a lost trial. Let me just be frank with you. If you lose a case, if you lose a trial, there's no reason to not use ESAS. I guarantee you. Don't be squeamish. Don't be afraid. The system is supposed to take into consideration similarly situated people. I know judges don't like to do that. I know judges say, well, I don't care what goes on in other judges' courtrooms. Well, let me be frank with you. You have to get over that. That is not how the criminal punishment code works. That is not how the guideline system works. They were specifically created by looking at prior cases that were similarly situated and what the average sentences were. I've done the research on this. I've gone back and looked at the law review articles from when they first were creating the guideline system in the state of Florida back in the 70s and the 80s. I've done all the research on it. And so I know you're going to run into judges that say, I don't care what other judges have done. Well, guess what? They're not doing their jobs. Now, you can't say that like that, but you can explain and educate judges on how the criminal punishment code is supposed to work. But before you can do that, you must educate yourself on how it's supposed to work. Because I'm telling you, most lawyers don't know how the CPC works and don't know how it's supposed to work. I'm just being frank with you. I've been there, done that. I got educated when we created the system, and I realized that I had not been practicing law to the optimal abilities that I could have had I had a system like this at my disposal. And so what this by the way, this former public defender, I did some research on him yesterday. Nick Kramparth, he's a prosecutor now in Daytona. I guess he got tired of being kicked around as a defense attorney. He decided to go the other way. I started in the prosecutor's office trying cases when I was an intern before I graduated from UF, and then I came over to the defense side, which I like a lot better. So this is the sentencing memorandum and request for judicial notice that he put together. Very fine document here. He did an excellent job on it. And he basically highlighted some cases that he found through his ESAS searches, and he appended them as exhibits. And this is how you do it. Because ESAS is nothing more than a LexisNexis or Westlaw or fast case, but for sentences. This is how you have to look at this. You don't go in court citing ESAS, just like you don't go in court citing Westlaw or fast case or LexisNexis. You cite the cases that you got from those sources. And so that's what you're going to do with ESAS. You're going to cite the cases, and these judges are going to be familiar with these cases because they come from each respective jurisdiction. So here's Exhibit A. He has a score sheet here for this Michael Core case, which is in line with the argument that he wants to make. Probation, 3 years, drug offender probation, based upon, let me show you something here, based upon 54.90 total sentence points. And his next case, Exhibit B, is State versus Marcus, Latin Marcus. And this is a very old score sheet right here, which had a total sentence points of 54.1 and probation, 3 years, under 66 points. So court sentenced the defendant, the drug offender, probation. So these are cases that are right in the jurisdiction that the judges are familiar with. And here's your real golden goose. You can use ESAS to find cases that the judge that you're appearing before have either sentenced someone on an open plea or by a plea bargain. And now the same prosecutor or the same office is asking the same judge to do something twice what that judge regularly does, because you can do that, the judge's averages with ESAS. And once you show that judge what her or his averages are for this particular case, it's going to be very difficult for that prosecutor to show why your case should be so different when the facts are not different. And that's what you want to be focused on. Okay, so I'm going to show you just about a minute of the video. Here's a good thing that you have. You actually have the video from the sentencing hearing. I edited it down to the pertinent part, so it's 10 minutes long, but I'm only going to show you about a minute of it, the end of it. But here's the video when the defense attorney from your office in Seminole County presented ESAS data to this particular judge, which I'm quite sure you who are in Seminole are familiar with her. She's still on the bench, which she probably is because she looks like a young judge, because this was back in 2018. But what I want you to hear with this particular presentation is how the prosecutor tried to game the system, how the prosecutor, he's not being fair here at all. He is really trying to go beyond what the legislative body wanted to do with respect to, 948, Florida Statute 948.20, which allows a downward departure type sentence in drug offender program for someone who is 60 points or less. So I'm going to take you to about 8 minutes, 40 seconds of this 10-minute, 30-second video. And so you can hear, you might want to cut your volume up so you can hear this, how this prosecutor is trying to game the system here. I think it's 8:40. Stop it right there.
Drug paraphernalia, given all the history, I understand the legislature's intent with allowing someone who scores above 44 or below 60 to be placed on some kind of drug offender treatment program. But although it is simple possession in both cases, given his prior history, I just don't see where the treatment is necessary. I don't think it's something where he asks for treatment. I don't.
Notice what he said. The prior history. I'm saying this one more time because it's so important. The prior history. Guess what? His prior history is counted on that score sheet. It's already accounted for. And so a lot of times what happens is judges and defense attorneys, both private and public defenders, get gamed when prosecutors start talking about their prior record. His prior record is calculated on that score sheet. And the legislature has already taken into consideration his prior record based upon the points that they said 60 or less. If they score 60 or less, even including prior record points, they still qualify for this program. But if you're not careful, you get gamed out of your client's rights by listening to a prosecutor make this kind of argument. Your counter argument is, Judge, his prior record is already calculated within the score sheet, but the legislative body, the Florida legislature, has already designated that he qualifies for a drug offender program, downward departure, even with his prior record, based upon the fact that it's 60 points or less. That's your counter argument.
I just don't see the point of going from supervision when last time he was on supervision, he wasn't able to do it successfully. He would be back before the court again. And then at that time, level one, he would qualify as a violent felony offender, especially in circumstances of the robbery charge, for other convictions. And we're just back to the same situation in a few months where he's.
Those are unreasonable and unfair arguments that he's making. He is speculating. As a matter of fact, I don't want to get into that, but he's making some arguments that need to be adequately addressed, if not objected to. I know this is not a jury trial, but my point is he needs to be put in his place as professionally as possible, because he's just stretching it, trying to get the disposition that he wants, even though he's not entitled to it based upon Florida law.
Now facing
Well, it is concerning that Mr. Miller is out on bond for possession of cocaine, and he committed another possession of cocaine. It does kind of perhaps it's a drug issue that he has and not a criminal issue. So I'm going to adjudicate you guilty at this time of all the charges that you pled to. You do score 58.5 points, which allows me to downward depart. Pursuant to 948.20, you do qualify for that downward departure. I do find that that's appropriate at this time, so I'm going to put you on 5 years of drug offender probation. You'll complete inpatient treatment and you'll remain in custody until a bed becomes available. Part of that inpatient treatment will have a grief counseling component.
Now, I took the time to look this up because I wanted to see whether or not Mr. Lucio was going to follow through with his probation. So today I took the time to go into the clerk's office and I see that he got discharged from probation. He was clean. He finished everything out. I'm looking at clerk's information. He paid everything off. He met all of these conditions: drug evaluation, substance abuse, residential treatment, random drug testing, everything he was supposed to do. He was a model probationer and everything. Unfortunately, I can't say the same thing about the next case that we're getting ready to look at because that just did not happen with the next person. Give me 1 second. I have a little issue on my end that I need to straighten out. Okay. Now this next case right here is from Brevard County. And this is the case that, this is the other case that I sent you all this morning on David Lucio. This is one of the saddest cases I've seen in a long time, to be honest with you, the ultimate outcome. But this video is only 5 minutes, and I want to play it for you. I reduced it down to 5 minutes. It's just the defense attorney's argument. And the reason I want to play this for you is because I want you to, she did an excellent job of presenting ESAS-derived data without mentioning technologies for justice, without mentioning ESAS. She just basically used the cases that she found with this tool, because that's all ESAS is. It's a tool to help you find cases that you can argue. Now, this young man had 10 second-degree felony possession of child pornography, so he's facing 150 years in prison. I think 10 on the bottom end, 150 on the top. And they would not negotiate with, this is Ms. DeGraff. I think she's in private practice now, Colleen DeGraff. They would not negotiate with her. And she didn't want to bid against herself, so she wisely ran some ESAS searches. And she was shocked at what she found out. On the positive side, it was so positive that she requested a downward departure or a youthful offender sentence. Now, you don't do that unless you have some serious ammunition, and that's what she had, and she got everything that she wanted. Unfortunately, Mr. Lucio did not carry his end of the bargain. He wound up getting 30 years later on after he got violated. But here's the hearing. Very important to listen to how she's presenting it, and then number two, how the judge responds to it, and how the state attorney tries to argue against it. But once you have this data at your disposal, it's difficult to argue against it.
I did file yesterday a motion for judicial notice of some other court files and sentencings. It's not to show this court that you're obligated to do something. I'll just summarize, and I did just very briefly in a little table on the 3rd page of my filing.
Regarding that judicial notice, I had time to review some of the cases. Some of the cases deal with an individual who is 57 years old. Another one deals with an individual who is 33 years old. One was 56. So state's position is that those cases are not indicative of anything, and the court should not take judicial notice of these cases, because there isn't other cases where the defendant got sentenced to life on child pornography.
If I may finish, I would.
Both should not be.
All right, you can make your argument. Go ahead.
Each of these individuals, and Ms. Osei actually started to summarize in a way that I see it in a different way. Each of these individuals who were granted downward departures didn't even have the benefit of asking for the court for a youthful offender. This is another opportunity and a reason for Your Honor to grant discretion. But I can tell the court that all four of these individuals, and I'll read the case names and case numbers into the record: Sean Beast, 2016, CF 29727, Kevin Matthews, 2013, CF 63147, Jeffrey Monk, 2010, CF 39212, and Robert Reagan, 2014, CF 37982. All were charged with more counts of child pornography, and I'll just say them in succession: 30 counts, 15 counts, 50 counts, and 12 counts. All but one scored more than Mr. Lucio. All of them were devoid of criminal history except for one individual who had one petty theft. The three ladders, Matthews, Monks, and Reagan, were all open pleas to the court seeking downward departure grounds. Downward departure grounds absent a youthful offender. Each of these individuals, whether they were adjudicated or received a withhold of adjudication, were placed on supervision. First one, 15 years probation. Second one, 2 years of CC followed by 6 years of probation. The third individual, Monk, a withhold and 2 years CC followed by 3. And Mr. Reagan, he got an adjudication and 2 years of CC followed by 8 years of probation. In fact, on Jeffrey Monk, in my review of the court file and what I've included in my pleadings, is that the state attorney on Mr. Monk's case, on the 2010-39212, the state appealed the granting of that downward departure because they believed that a sufficient basis was not presented. The 5th District Court of Appeals affirmed that and stated that the downward departure stands, that sufficient grounds were laid.
Let me just interject here. That's very important that she found that, because what most judges want, if they're gonna stick out their neck to give a downward departure on a case like this, they want to make sure that it's going to stick. So if you can provide some type of legislative authority, appellate authority on it, you're halfway home, subject to your facts.
Now, obviously, even with the most close of circumstances, and my attempt to compare apples to apples is still, I know, and I will assert to this court, is still a situation where we have different individuals in different circumstances.
Let me just interject right here on that, because that's the argument that the state makes a lot. You know, different cases are different. Well, factually, yes, but not as a matter of law. As a matter of the law, the score sheet determines now, when you're dealing with crimes that involve victims, it's different, okay? Because you can have a different level of injury. But when you're dealing with a burglary, a grand theft, uttering forced instrument, all of them were done the same, okay? So the facts will not necessarily matter. What matters as a matter of law is the document was forged or the document was presented. Doesn't matter whether it was presented to a bank or a hospital or a doctor's, doesn't matter where it was presented. What matters is that it was presented and it was fraudulent. And you got so many points for that, irrespective of whether it was done in 10 buck 3 or 10 buck 9, okay?
But I can assert to the court that we've provided this court with 3 different options for downward departure, and the other ones that did seek a downward departure were for the specialized treatment aspect, similar in that regard, but they did not have the other 2 reasons for a court to depart, meaning his youth or being under 21. I can tell the court that in Sean Vest, the first offering, the individual with 30 counts, that was negotiated with the state for a withhold of adjudication of 15 years of probation.
Now, let me just interject right here, because that's very important. A lot of times what some judges will say, well, you know, you're showing me pleas. This is an open, open plea with a contested sentencing hearing. Why are you presenting to me, defense counsel, why are you presenting to me plea bargains? Well, I'm presenting them to you because when the prosecutors have unlimited discretion into how they can dispose of a case. And so when they bring it to you, you sign off on it. And that is, once you sign that order, Judge, that's your case. That's your sentence. Okay. And so all I'm asking you to do is look at what they normally ask you to do. And I'm asking you to do the very similar things that you do when they ask you to do it, because you have the power to do it now. And if you have the grounds to ask for statutory grounds to ask for a downward departure, you need to do that, because the state attorney can give a downward departure for whatever they want to, which means they have way more power than the judges. And so when you educate the judge on the power that the prosecutors have in relation to the lack of power that they have, judges that is, in terms of entering a downward departure, you can bring them up to speed real quickly on, look, judge, if the state attorney is normally asking you for 5 years, or agreeing to 5 years, on plea bargains. But since we did an open plea, why are they asking for 3 times that amount? That's unreasonable. And so I'm just asking you to do what they normally ask you to do. That's your counter argument to the judges.
So it's not without precedent. And again, this is not to suggest the court and tell the court what you should do, but it shows the court, and I hope it shows the court, that you have the ability to do so. And we cannot ignore the principles of proportionality, and we cannot ignore the fact that there's other individuals out there that are very, very similar, if not worse off, factually and in mitigation, worse off than Mr. Lucio, and they've been given the opportunity to prove themselves on supervision. I thank the court. Mr. Lucio thanks the court for its time and attention to this matter. We pray that you grant this motion for downward departure and for youthful offender.
I spent a lot of time thinking, what is right here? And, Ms. Lucio, I'm taking into account your age. I am going to sentence you as a youthful offender over the state's objection.
Now, there's no way that would have happened without that data, without that excellent argument that she was doing. It just wouldn't have happened. One of the other things that's important in this particular case, I learned that this particular judge in Brevard County, she had been on the civil bench. She had been on the criminal bench before, but she went on the civil bench for a long time, and she had just come back to the criminal bench. So she was kind of rusty with criminal law. And so she was a perfect candidate to submit ESAS-derived data to, as well as any judge who just comes to the bench, has not handled criminal cases before or anything like that. They're perfect candidates for ESAS-type information. Give me 1 second here. I gotta come out of this screen and go back to where I was. So we're gonna try to run some searches here. Give me a second. Application window. You stop the share. Let's get this turned around with these right here. See if I can go here. All right. You should have up. Yes, I see it now. So now we're gonna go into ESAS. Let me hide this floating panel. And okay, so here are the dynamics of ESAS. So you got the home screen, my account, reports. That's for me, really. I don't think you have reports. Help, log out. Okay, now search function. You got 3 different ways to search. If you want to search for a specific defendant's name, like for instance, let's say you want to look at a prior case of yours and see what the average sentences were in relation to the disposition that you got. You can look up your client's name and go and check it out. You can search by docket. You can also search by statute. We're going to be doing a statute search. Here are your offense levels. Okay, you can search by offense level, or you can let it default to all. It's probably wise once when you first learning how to use ESAS, go to all. Just let it default to all until you learn the system. Okay, the offense date range, January 1st, 1998 through currently June 30th, 2025. We get a data dump once a year from the Florida Department of Corrections. Okay, our data starts from October 1st, 1998, currently through June 30th, 2025. So that's over 2 million records from that span of time. However, it's not complete because if a prosecutor makes a mistake on a score sheet, the clerk's office turns it over to the FDOC. If it's a critical error, the FDOC will send it back to the clerk's office. The clerk will give it back to the prosecutor, and that prosecutor has a certain period of time to correct that score sheet. If they correct it within the period of time and the clerk resubmits it, it'll be included in the data that we get. If they either don't correct it properly or fail to submit it on time, it will not be included, which means that every case in your clerk screen is not in ours. However, we probably have well over 97% of the cases. But I've seen situations whereby I had to tell attorneys, look, go and get a public records request for this particular statute, for this particular period of time to make sure that we're not missing anything. Okay, so you should have all circuits available. You want to search all circuits, you hit all, and all of them will come up, and all 67 counties that's representative of all 20 circuits will come up. You have a standardized search, which I'll show you in a minute, the differences between the standard and the detail. Okay, come down here, you're gonna put your statute number in. We're gonna go with 794-011, and that's a sexual battery slight force. And I'm gonna put 154 points because that's the first offense. I'm gonna put it in both boxes. This is an apple to apple and an orange to orange search. You're not gonna get a lot of cases. You know what, let me do this first. I'm gonna get a lot of cases first. 9999, that's 4 nines in that second box will pull up every case that's in ESAS that has been submitted by the Florida Department of Corrections from October 1st, 1998 through June 30th of 2025 in terms of the sentence dates, okay? So now I'm gonna come over and uncheck all these boxes. I'm gonna come down here to Circuit 18. I'm gonna check Circuit 18 Sanford. Now when I do that, 2 boxes are gonna light up over here, Brevard and Seminole, because those are your 2 respective counties, okay? So now, if I were to click 4th Circuit to pull up Clay, Duval, and Nassau, some circuits have as many as 5 counties in them, okay? Now, once you have your information in and everything, oh yeah, let me do one more thing. Down here, we're gonna pull in all the data, but let's say you only wanted to look at legal status violation cases. You just click that box only, and only those cases are gonna come up. Let's say you wanna look up VOP and legal status violation cases. Only those 2 will come up. If you check any one of these boxes by itself, only those cases, if they exist, will come up. But the best practice until you learn it is to let it default to all. So it's going to pull up all the information, and then you can sort out what you don't want, but you're going to have everything at your disposal. So now I'm going to hit search. This is going through 2 million records, and within a second, it came up with 311 cases. Now, I'm circling right here, 311, top left, record count, 311 cases. Now I'm gonna go down here to the bottom right. There, look at your bottom right screen. It says 1 of 9 pages, 311 items. Now, when I start sorting, this number is gonna change. It's gonna get reduced by the cases that are being eliminated. For instance, let me show you the data fields here. Now this is a regular search, not a detailed search. Okay, but with a regular search, you can get detailed information, like if you hit show details, it'll explode it. And so when you're looking at the regular standard search, which I started, that's 21 data fields. When you hit show details, it's gonna bring up some more data fields, up to 34 data fields. When I come back and do a detailed search, it's gonna pull up 42 data fields, which is pretty much everything that's on a digitized score sheet, all right? So this shows you how many, these points right here, these are what make up this. 92 primary offense points, no additional offenses, victim injury, prior record, legal status, none, violation of probation. So this is a VOP case because it has points in it. So If you don't want to look at VOP cases because your case is not a VOP, you want to hit 0, and this is going to eliminate every VOP. And now that reduced it down from 311 to 243 cases down here, 3 VOP. Now, if you have a VOP case, what you want to do is you want to deselect 0 and select all the VOPs. That reduced it down to 68 items. But these are all violation of probation cases. Now, let's say you don't want to look at legal status violation. I don't know why you wouldn't, but let's eliminate that. So now you're going to get rid of the legal status violation. Now you're down to 60 cases. But these are all VOPs with no legal status violations. And so when you come over here, you have a minimum mandatory, if there are any. I need to come back over here and go put everything in here. If there are any minimum mandatories, it will be in this box. The minimum sentence the person's facing is in this box, minimum sentence. The maximum exposure is in this box. Now, over here, when this box is lit up in blue, it's telling you that the sentence in this box is less than the minimum sentence, which means it's a downward departure. And so Buster created this. Is real cool. So you don't have to actually go into the score sheet. You can just see every one of these that's highlighted as a downward departure. Now here's one caveat, very important. Don't just go by this, because sometimes the box isn't lit up. But when you go into the actual score sheet, you'll see that the sentence is less than the minimum sentence, but for whatever reason, the box wasn't lit up. So don't just go by the box. Now, come over here, you're looking at the sentence type. That's a municipal ordinance provision. That's an unusual sentence that's not going to be able to be documented on a score sheet. That's going to be county jail. And when they're lit up, it shows you the split sentence. That's county jail. That should be 60 days, because that's in months. That's 2 months, 60 days. This right here is county jail, 60 days, community control, 2 years. This down here is 1 year community control, 1 year probation. The disposition type is in this box. It's a plea. The sentence date, the offense date. Now, here's a good feature. Let's say and I set this up just to do this training, because I don't normally have my screens like this. Let's say you want this to be over here. You can just click it, drag it, and drop it, and it'll change it for you. Now, you have to hit save columns for it to stay there, because if you don't hit save columns, when you log out and log back in, it's going to revert back to however it was set up, okay? So now you have the judge's name, the docket. Now, if I click this, it should go into the docket. Let me see if your screen is going to change. Hopefully it will. No, it didn't. So that means I need to do something different. Give me 1 second here. Let me come out of this. And yeah, I didn't like that. That didn't go well. So let me try another screen share here. Go here. Come back here. Yeah, there we go. Get rid of floating panel. Okay, now, here's what I just did that you couldn't see. I'm going to click the docket, and it's going to change the screen to a digitized score sheet. And this data right here, this is just the way Buster, our CTO, designed our score sheet, but it took raw data from your score sheet that's turned over to FDOC, okay? And so this is how it looks in ESAS. So these are the data points that's coming up that we're looking at. And you see victim injury here, 80 points for sexual penetration, okay? You hear community sanction violation here, community control, new violation on this particular case. So that's how the dynamics of that looks, okay? And so come over here. I move the offense date. So let me move it back. The county, you can go into the clerk's screen right here. If you click this right here, take you right to the clerk's office. Buster added that feature a couple years ago. Defendant's last name, first name, date of birth, age, race, age at sentencing, race, and sex. Okay, now, I'm going to return to search and show you something a bit different. Now, This is a standard search we were doing. Let's go to detailed search. It's going to pull up 34 data fields. I think every data field that's on that score sheet, it's going to pull it up. So 311 cases again. You see way more data. Let's go through the data. Statute description, felony degree, offense level, points, primary offense points, additional offense points, victim injury, prior record, legal violation, VOP, VOCC, weapon, prior felony, enhancement, sentence type, sentence years, sentence in state prison, county jail, control, probation, minimum maximum sentence range, disposition, minimum mandatory, if any, habitual offender, habitual violent offender, violent community control, I think that is, docket, race, sex, date of birth, age at sentencing, age at offense, sentence date, offense date, judge name, last name, first name, county, circuit, and prepared by. This is the prosecutor. This is a very, very important data field right here. Why is this so important? Because if you have Jacob Polk on your current case, and it is a sexual battery with slight force, and he's trying to get more out of you than he's normally done, then you have some ammunition based upon other cases that he's allowed to be played out, especially if those facts are more egregious than yours, your cases, your cases facts are, you have a good argument. Now, one thing I didn't do that I'm going to do, we're looking for sexual battery with slight force. And so you want to come over here and sort, because as you can see, you have level 8s, level 9s. So here's one sorting feature. I only want to look at level 8 cases. So I eliminate everything else, come over here, hit level 8. That's going to reduce those cases down to 70, from 311 to 79 cases. Now I want to make sure that I only have 794.0115. You want to keep 011 because it could be a 115. It may not be. You'll find that out in a few minutes. 0115, that's sexual battery slight force. And we're going to do a 0115A as well. So come over here and hit OK. And now you're down to 61 cases. And so you're looking at sexual battery, no injury, or not likely to be injured. That's what you want. All these cases are like sexual battery, not likely to provide, to have caused injury. Look at all these statutory descriptions here. All of them are second degree. Here's one that says life. That shouldn't be the case because this is not a life offense. So you want to get rid of that life charge for sure. And look at what happened when I did that. Let's go back here. Let me go back to that. Okay. Yeah, that should be, I'm gonna go back to level 8. I'm gonna come over here and sort these points, by the way. Once I click this right here, it's gonna sort these points from lowest to highest. Now, we're looking for a first offense, which is gonna be 54 points, okay? So if it's not 54 points, we don't wanna look at it anyway, because we're only looking at first offenses. And let me show you why or how that is. You come over here and look at the score sheet. On the first offense, you're going to have primary offense 74 points plus victim injury 80 points. On a 794.0115 second degree 8th level sexual battery not likely to cause bodily injury. That's a 74 plus an 80. And so you have apple to apple and orange to orange cases right here. Now you have mostly pleas. You have 11 cases, 9 pleas, and 2 trials. Let's eliminate, well, let's do a statistical analysis right here of all of these cases. As we see, 1, 2, 3, 4, 5, 6 are downward departures, okay? Now listen, these cases carry the same amount of time, okay? From 7.9 minimum to 15 years. Yet, look at the divergence of sentences, okay? That shouldn't be. If the CPC is working right, this shouldn't be. Why? Because all these people have the same points, okay? Now, if it was a sexual battery with great injury, it would not even be 794.0115. It will be a level 9 offense or something like that. And so this is showing you that there is inequity and improper proportionality in sentencing. Look at this, community control, 1 year, 14 years probation, 1.5 years community control, 10 years probation, 2 years community control, 4 years probation, 5 years state prison, 10 years probation, 6 years probation, 8 years state prison, 7 years probation, 10 years, 15 years probation on a plea. Now, these are old cases. So if you want to sort the years, sentencing dates, they go from 1999 to 2025. Somebody just lost a trial in 2025. Okay. So what I was getting ready to show you is the stats. Let's do the statistics for all cases, trials and pleas, just to see what the average sentence is in this circuit for these cases. The average sentence is 6.5 years. As we see, community control, 4 cases, minimum 1 year, maximum 2 years. State prison, 4 cases, minimum 5 years state prison, maximum 15 years state prison. Probation, 3 cases, minimum, the lowest probation 2 years, maximum 15 years. All 11 cases, 1 year minimum, 15 years maximum. That's a serious spread. Okay, so you have the average sentence, and here the median years right here, 5 years. Now, that's for pleas and trials for the jurisdiction. Let's eliminate the trials and look at the pleas. And then you're going to do the stats again. Sometimes you have to do this twice. No, you didn't. Okay, so now 9 cases, 5.5 years versus 6.5, I think it was, years on the pleas, which is not that bad. Okay, now let's look at the trials exclusively. Come back over here. I'm going to bring the trials back in and eliminate the pleas. 2 trials. Let's do the stats on these 2 trials. And the difference is 8.5 year average with a minimum median of 8.5 years. That's 3.5, that's about 3 years difference between, that's a 3-year trial penalty, basically. That's what that says in a nutshell, okay? So now, that's how you run the data. So now, do you all have, somebody's gonna have to unmute and tell me, do y'all have your computers with you? I want you to run a search with me. Do you have your computers? Yes? Hopefully at least one person does. Okay, so I want to run, oh yeah, what I did is I want to show you something different. Let me show you. Let's say you only want to search for Brevard. So you click none here, none there to make sure you're clear, hit Brevard only, and then you can search for Brevard. I'm going to go back to the standard search field, search Brevard only. And so that's 220 cases. I'm going to come over here and sort only 11 level 8 cases. That reduced me down to 59 from 220. Now I want to come over here and make sure I'm only looking at 794,011. And by the way, as long as your case has the same offense level and receiving the same points, you can still make an argument for a different type of offense as long as the offense levels are the same and as long as the points are the same. 74 for this, 54 for that, whatever the case may be. So now, come back over here. That reduced it down to 3 cases. These are apples and oranges to oranges, 154 points. That's the first offense. And so we look over here, these are pleas from 2000, let's sort the dates, 2010, 12, and 14. Sentence dates, that is. And here's the judges. Let's do the stats on these cases right here. And look at that, 14 years. That's huge in relation to what we've seen. Let's go back and do Seminole. So I'm going to click none here, make sure none is there. Let's go to Seminole and do the same thing for Seminole. And you can do everything at once and sort it out, or you can do one at a time like this right here. 91 cases for Seminole. I'm going to go with a level 8 only. That's pulling me down from 91 cases to 20 cases. Then I'm going to go over here and 794-0115 only. Take that A. You don't want that B. Now I'm down to 14 cases, apples and apples, running from 154 to feet. The sentences are, the minimum sentences are 7.9 to 33.2. By the way, if you ever see this right here, that means life. 9999, that means life. And so when we sort the points, they're running from, the sentences running from, all these are down with the vast majority of these are down with, or the majority are down with departures, okay? So now you got 2 years community control, 2 years probation, 4 years state prison, 4 years probation, 9 years state prison, 10 years probation. Let's eliminate the trials and look at the stats. In Seminole, that's 4 years less than the average for, actually that's not right because those are different. Those are not apple and apple and orange to orange comparisons in terms of the point ranges, okay? Because this is 154 down to up to 558. But if we look at 154 only, well, not enough to do. So basically, this person had probation 15 years. Okay, now I want us to run a search together. I'm going to return to the search. Now, what I'm going to do is hit reset. It's going to clear everything out. Everything out. Now I'm going to start over. So now I'm going to look at our DUI manslaughter 316.193. And I'm going to put 194 because that's the minimum. Okay, that's a first offense. First offense, DUI manslaughter, 194 to 194. And the reason that is because it's let me look at my cheat sheet here. It is 74 primary offense points plus 120 death points. That's what makes 194. So I'm gonna come over here and do clear that out and hit Sanford, which is Brevard, and got nothing. No apple to apple. So now let's go to 9999. It's gonna pull up every case that is a DUI manslaughter from these two counties in this particular. Wait a minute. Oh, that's the problem. 193. That should be 193. That's a good thing right that I made that mistake. You saw what happened when I hit 19. When I put 103, nothing came up. So let's go back. I didn't catch that at first. So let's go back to 194 based upon that error that I just made, and I made it inadvertently, but I'm glad I did because it showed you what happens when you make that mistake. Now, 21 cases came up, DUI manslaughter, level 8, 316.193, C3. Look at all these downward departures. All these downward departures. Now, let's look at the counties. Let's look at only the cases that are in Seminole. So I can eliminate Brevard, go to Seminole, and that reduced it down to 9 cases. Let's do some stats on the, here's another good thing that you should know. Unknown means that box 12 on the score sheet, which has the plea or trial, was unchecked on that score sheet. That won't void a score sheet, but when that box is not checked, FDOC will leave it alone. And what Buster will do is put unknown because it was unchecked. So that's what that is. Okay, so now let's look at the pleas only and do a statistical analysis on 6 pleas in Seminole County. And that is 2.37 years. That's amazing for a DUI manslaughter. You know that's amazing for a DUI manslaughter. Let's look at the trials. And for this right here, you have to go into the clerk's office and look at what happened. That's the only way you're going to find out what happened in that particular case. So we only have 2 cases with Judge Rex Seidler and Judge Alva. So let's look at these stats on these two cases right here. 8.2 years. That's a big difference. And so this is the power of a system like this. It shows you how, what comes up and everything else. And so that's pretty much how you use ESAS. We get more minutes, and I want to give time for a Q&A. It's supposed to be 10 minutes, but this lasts a little bit longer than I thought. Any questions from anybody, please, ma'am and sirs, right now? Any questions? And you can put them in the chat at this point because I can't.
I have one question.
Okay, go ahead.
Is there any appellate case anywhere in the state of Florida where the state has appealed a downward departure that was granted based on this equity argument, and the appellate court said that that was a valid grounds for downward departure?
No. And let me tell you, that's an excellent question. Thanks for asking, because it reminds me of something. The case is I'll send it to y'all. It's called State versus Cosby. Cosby. It was a PD case from one of our clients, which was Tampa. They handled this case, and here's the mistake the lawyer made. They reversed the judge did grant the downward departure, but it was reversed on appeal for one reason. Here's the reason. The reason was the lawyer did not provide any score sheets, any arrest and booking reports, any judgment and sentences for those cases that were relied upon, like we're suggesting that you do here, like the case in Seminole County. The guy provided the score sheets and everything. So the court reversed that, but here's the good news. The court said that the trial court had insufficient information to have made a downward departure. That was the problem. So the court left open the fact that a downward departure can be made on proper grounds. And so I've been trying to work with lawyers since then because I think that was back in like 2018, 19 or 20. I've been working with lawyers. So I want one to go up, based upon somebody providing all the information. And so in order to bulletproof your sentencing memorandum, don't just provide the cases, provide the score sheets, provide the arrest and booking report, and provide the judgment and sentence. That way, the judge can look at the dynamics of each respective case that you're relying on to bolster your argument for a downward departure. And then you can submit Cosby along with it as an exhibit, explaining to the court that the only problem, because prosecutors use Cosby all the time. Okay, I'm an expert witness. I testify all the time. And so they bring up Cosby. So I have to clarify to the court that nothing wrong with Cosby. It was the defense attorney did not provide the sufficient documents to provide the trial court an opportunity to actually make an educated decision with respect to a downward departure. So I'll send that case to you. And there's one more. I can't think of the name of it. It's a twin case with that one. But both of them basically say it can be done if you do it right. And that's why we provide you with this information to show you how to do it the right way. Excellent question. Any others? We got 2 minutes. If you get in a jam on a case, like a huge case, even though you have this system, sometimes they'll hire me as an expert to not only run the data for them, because I can run it a lot different. I have years of experience. Let me show you some of the things I do. Like, for instance, let's say a lawyer wants me to run a case for DUI, manslaughter. No, leaving the scene of an accident with a serious bodily injury. This is a good one. So I run that data and I find all kind of horrendous sentences. So I said, well, let me see how the sentences look for leaving the scene of an accident with a death. And invariably, I find lighter sentences for leaving the scene of an accident with a death than leaving the scene of an accident with a serious bodily injury. So I figured what it is the person with the serious bodily injury, with the lost hand or foot or eye or arm, they're in court. The judge is looking at them, okay? But the death cases, they're not there. And sometimes they probably don't have family members there. And so I don't know the exact reason. That's what I surmise. But across the entire state of Florida, I usually find lower sentences for death cases. We just saw it. DUI manslaughter cases, leaving the scene of an accident with a death case versus DUI with a serious bodily injury or leaving the scene of an accident with a serious bodily injury. So sometimes you can run a more egregious case than yours and show this judge that he has or she has given out sentences that are better on worse cases than the prosecutor is asking on this one. Very powerful argument to make. All right. Anything else? We are out of time. It's 3:30. I'm going to cut the recorder off if there are no questions, and then I'll give you the CLE number. Are there any more questions? Going once? Going twice? Okay, let me stop recording. Thank you all, by the way. I know it was mandatory, but thank you for attending. And you will, there is a brief, very brief 7-question survey that will go to you when we end the meeting. Please fill it out so it can help us, adjust these seminars for future attorneys.